Right, so this is the third video in the police set, and it's detention. So you've got stop and search, arrest and detention. As you can see from the top of the page, it is still governed by PACE, but there isn't a set section for detention, as there's a lot of different areas that do cover different aspects during a detention. So as long as you say that it's governed by PACE, 1984, you will get the credit. Now, there are three main areas, so the detain process, interviews and searches and samples. So there's three main areas that you'll need to cover. As always with police, make sure you watch the question and read it carefully. So this is quite important. So it asks for the power to detain an interview, so that's just what a detain an interview. Rights when detained, interviews and searched is everything. Rights during detention is everything. Just be very, very careful. And the question that you got in summer are all about the custody officer. Obviously, the custody officer is a big part of detention. So they want a detention for that one, minus the interview stage. So you just need to be very, very careful. If we start with the detain process then, there's four areas that the examiner's looking for. What involvement the custody officer has, the time limits during the detention, legal rights of citizens, and then the Code C guidelines. Okay, so I'm just going to take you through all four, get you to add notes to the side so that you've completed it. Right, so starting with the custody officer then, the minute you get arrested and the police do the toast procedure, the last T is that you should be taken to the station as soon as possible, really. And so this takes place as soon as you arrive at the station. You need to be seen by the custody officer as soon as possible, basically, because your rights are hindered until that. Okay, so as soon as you get there, you need to make sure that you are checked in with the custody officer, because they are responsible for your general welfare. It's their job to look after you. So you sustain any injuries or are death whilst under their care, then they will be responsible. Key responsibilities of the custody officer then, they need to check that you know that you've been arrested, why you've been arrested. So they're checking that all elements of toast have been performed, basically, by the police officer. They'll record everything that happens, such as how long you're in your cell, how long you're in interviews, whether you've had a phone call, your solicitor, when you've gone to the toilet, anything that goes on, they will be checking. They'll take and record any possessions, so things like your phone, wallets, belts, shoelaces, so you're not going to hang yourself. Any possessions that you've got on you, they'll make sure that they take off you. They'll perform a non-intimate search to make sure there's nothing on your body before you enter. Take your fingerprints so that they can match them up on file and they know who you are. And then finally, they'll review the detention. What I mean by reviewing the detention is making sure that you should be there, basically. So if the custody officer thinks there isn't enough evidence for you to be detained, he will order that a review takes place in order to let you out. But it will generally check on you as well. So they'll check on you after the first 6 hours. And then every 9 hours after that, they'll check to make sure that everything's okay. So there's a set process in terms of when they should be checking that everything's all right. In terms of time limits then, your custody officer obviously has an involvement here because he's checking that you should be there. But the maximum you can be kept for any offence is 24 hours. And at the end of that 24 hours, they either need to release you, either on bail or completely release you, or they need to charge you. All right, so that's what they need to be doing there. What they can do is try to extend the detention time, so they can try to make it up to 36 hours, but only, as you notice, if it is a serious offence. So they can only keep it up to 36 and 96 if it is an indictable offence there as a result. Now, 36, then you've got to ask permission from a superintendent, so somebody high up, a high-ranking officer in that station. They might allow you to do that, reasons being you might need to have some more interview time, they might be waiting for some evidence to come back, some witness testimonies. So normally they do it just to try and interview a little bit more in the hope that you will confess. They might think, look, she's really close to confessing to this crime, can I just keep her for an extra few hours just to check whether we can get her or not. So they can apply to try and keep you up to those 36. If they feel like they want to keep you up to 96 hours, again they can, as long as it's indictable, but they do have to ask permission from the magistrate's court. So they can't just turn around and say that they want to keep you for 4 days, because that is a long time without charge potentially. So they're able to try and keep up to 96 as long as the magistrate's court agree to that. It applies for everything but terrorism. So terrorism, they can keep you for 14 days without charge. So it's slightly different there. Obviously, we're trying to protect the public, and if we do suspect you of a terrorism offence, we're hoping that by keeping you for that amount of time will hinder any sort of plans that you do have. Obviously, we are aware there's other people there as well, but we still need to keep you slightly longer so we can make sure that all the correct procedures are followed to try and stop anything going off. So yeah, 14 days for terrorism. Then we move on to the legal rights. So you have a certain amount of legal rights while you are at the police station. And as you can see there, there's 3 that you need to fill in. So first of all, you've got the legal right to have somebody informed of the detention. So the right that somebody knows that you have been detained, and that's under section 56 of PACE. So if you just want to fill in this box here, what we're meaning is that you tell a friend, you tell a relative, anybody really that is looking after your welfare or that's interested in your welfare, you need to let them know that you've been arrested and that you're at the police station. So if you just want to fill that in there, so friend or relative, etc., letting them know that where you are. You also need to have access to legal advice. So this is under section 58 of PACE. So now with this, it's either your own solicitor, if you have a solicitor that you fund, or a duty solicitor, which is free, provided by the government. So it depends on your situation, really. If your family has a solicitor that you always use, you might want to use them. Otherwise, you just have access to a duty solicitor. Now, that solicitor will either come to the station or give you advice over the phone. Sort of depends on who it is, whether it's duty or not, and what your sort of discussion with them is. So if you want to bob in there in your box, it's either a duty solicitor or your own solicitor. And generally, they'll give advice over the phone. You've also got the right to see all the codes of practice. So you get to see the codes of practice that are involved with PACE. So we've got starting up from code A all the way to code G that you can use. Now, the most popular one here that you'll be looking at is code C. So code C guidelines will be what you're looking for to go through there. So if you want to fill in there, it'll be code C guidelines. Okay, right, limitation then, you've got a little limitation at the end there. So there's 2 rights that are most important, which are these 2. But it says there that they can have them delayed for up to 36 hours by a senior officer if it's a serious crime and they think it's going to lead to interference with evidence. So what we're talking about here is that a senior officer can delay those 2 rights if they think that it's going to involve you trying to escape or trying to interfere with evidence. So they won't let you ring to tell somebody where you are, in case during that call you're going to say, get rid of the gun. Or they can delay the right to have legal advice so that you're not going to again say to your solicitor, look, we need to mess with this evidence, we need to try and escape, yada, yada, yada. We don't want to do that. Now, the problem that we've got is, Samuel highlights a very, very big flaw when the police have tried to do this previously. With those 2 rights, if you're going to delay them, you need to delay both of them or none of them. Now, in Samuel, they delayed 1. So they allowed him to speak to his mum, but they didn't let him speak to a solicitor. Now, ringing to speak to his mum is clearly then going to say, get me a solicitor. So then delaying his right to a solicitor isn't really delaying a right, because he's getting that right back because he's able to speak to the solicitor. So what you do need to do is either delay both or none, because in that instance where you're allowing 1, the other person could be alerted by them at the same time. So a solicitor could tell your parents, or your parents could ask for a solicitor. So they messed up here because they need to delay both rights or none. So just add at the side of this here, just that they need to delay both rights or do they need to delay none of them. Okay, Right, Code C guidelines then. Code C guidelines cover any sort of treatment of those people that are detained, and it governs things like when you're questioned, your rights during detention, what things you're allowed to have. Obviously it's guidelines, but generally if they don't follow Code C guidelines it is a problem. So most officers will make sure they uphold it. Now you've got an example there, so you've got a telephone. That's your first example of a Code C guideline, that you're allowed a call of reasonable length. So a call of reasonable length. Second Code C guideline, any medical treatment that you require. Any third Code C guideline, that you're allowed your 3 meals a day. So 3 meals a day. And finally, 8 hours sleep, but it's got to be continuous sleep. So they're not allowed to give you 3 hours sleep, wake you up and then give you another 3 hours sleep, for example, and then get you to go wake up again and then give you another 2. That's not allowed. It's got to be 8 hours continuous. Right, in terms of the interview then, what we're looking at here is the fact that it spells out the word cats, okay? Now, with the interview process, what we generally do is we try to get more evidence out of you, really, or trying to get more information. It used to be that the interview process was primarily just for sort of getting you to confess, really, trying to get you to confess to the crime. But we don't do that now. And as it says there, the Criminal Justice and Public Order Act restricted an individual's right to silence. So if you are silent now, it will be taken as a negative. We will draw a negative inference from that. And what we mean is that we'll think that you're being silent because you're guilty, in that sense. So you've just got to be aware. Right, 4 stages to the interview process then, and it spells out cats. So the first is cautioned. So we will caution you at the beginning of your interview and then after any breaks. So you'll have seen the caution on the TV, so talking about the right to remain silent, anything that you do answer, that you do relate on in court, you need to make sure you talk to them about it beforehand. So it'll be the big spiel, and they'll do that at the beginning of the interview and after any breaks. Appropriate adult then. So an appropriate adult is required if you are under 17 or mentally unstable. So you need somebody there because of your mental health. And if the appropriate adult isn't given, that is when the interview will become unlawful and they'll have to destroy the tape. They won't be allowed to use it. Now, this appropriate adult can be a friend, it can be a relative, it can be anybody that's in the legal profession. It doesn't have to be anybody in particular, which is good in one sense because it might mean that you're being interviewed with like a parent or a relative sat next to you, so you might feel a bit safer, but bad because that appropriate adult doesn't really receive any training. So when they're talking to you and trying to help, it might actually mean that they are hindering the investigation. They might make it worse, for you anyway. Right, case of Aspinall then. This was a boy that was schizophrenic and he needed an appropriate adult. But unfortunately, when he was interviewed, they denied the appropriate adult and he was interviewed without it. So any evidence that was taken from that case had to be destroyed. We couldn't use the videotape because he'd not been given the appropriate adult that he needed. So if you just want to fill in a few key words next to Aspinall, so it was just schizophrenic, needed an appropriate adult, but he didn't have one. So the interview became unlawful. Tape recorded then. So we tape record our interviews now, so it protects you and also protects the officers. So the officers are not saying that you've said or done something and you're not saying that they've said or done something. Obviously a few years ago, going back 20 years maybe, during the interview process, they used to be able to do anything, threaten you, beat you up, whatever, torture you to get you to confess. They can't do that now, and the tape recording protects you that from happening to you, but also it protects the officers at the same time. So there'll be 2 copies made. One will be readily available for you to use in court, and one will be available for them. And then finally, you're allowed your solicitor present unless it's been delayed. So your solicitor can be in your room during your interview, but obviously if they have been delayed, it can only be up to 36 hours that they will delay that as a maximum. So you could just get interviewed after that point as well. But yeah, you just need to make a note of that you will normally have your solicitor unless they delay them for up to 36 hours. At the bottom of the page then, Code C also applies to the interview. So whilst you're interviewed, there's guidelines in terms of what should be followed in that sense. So first of all, if you want to just bob in, you just need a few examples really. So that your interview room needs to be well lit, it needs to be well ventilated, you need to have breaks, you need to have refreshments when you need them, i.e. you need to get a drink or something. You can't be stood up all the time, you need to be able to be sat down. So there's just set guidelines in terms of whilst you're interviewed what needs to occur. Final section then, so the top of the page, the reason this is in a box is because you'd only talk about this if it wants individual rights, and it's just talking about section 76 of PACE. So when I mentioned earlier, the reason why we tape records, making sure that they're not beating you up, etc., it's now under PACE that they can't do that. So, as it says there, the court may exclude evidence that's obtained through oppression or torture. So, forcing you or torturing you to get some answers, that is not allowed and they can't use the evidence. So, you'll have researched Guildford 4 and Birmingham 6 so that you're able to then work out that in those cases they were all tortured, they were all beaten up to confess and they'd not actually done the crime, but they threatened them that much that they'd hurt them, they'd hurt the families, that they did actually admit to the crime that they never committed. So if this is asking about individual rights, you just need to make sure that you include that if possible, just saying that, you know, one of your rights under section 76 is that you're not being tortured to confess. Last area then, searches and samples. So while you're at the police station, they can do searches and take samples from you, but they've got to make sure that it progresses the case. You'll have an initial non-intimate search when you do get to the station and they'll take your fingerprints, but generally that's as far as it goes unless they can prove that doing other searches and taking other samples will materially progress your case, okay? So you've got strip searches, and you've got intimate searches. Well, strip searches has to be done by a same-sex officer, and they're doing half a clothing at a time. So they'll take your top half off, put it back on, and then your bottom half. That's how they'll do the strip search. Now, they're looking for anything that's concealed, so anything that you're trying to hide. You might have sellotaped it to your stomach, for example. So they just want to check to see that if that's what you've done. Intimate searches then are authorised by a superintendent, so somebody high up, but because it's intimate it needs to be carried out by a police doctor or nurse, okay? Now they're checking all orifices barring the mouth because the custody officer can do that. So they're checking every hole in your body basically to make sure that you've got nothing there. So you might have heard of the old phrase cough and squat when you're going in to visit people in prison. That's what they'll make you do so that if there's anything there it will automatically fall out. Okay, now it's looking for drugs or dangerous weapons, but you're not allowed to do intimate searches for anything that's stolen. So if they are doing that, it is completely unlawful. That's not allowed to happen. Final bit then, your samples. So there's 2 types of samples we can take. Normal samples, which are known as non-intimate, or intimate samples. Okay, now non-intimate samples, if you want to fill in there then, we don't need your consent, we can take these by force. Right, these include things like fingerprints, hair samples, saliva. These are things that we can take by force, so we don't need your consent for them. Whereas intimate samples, if you want to fill in, these are things that we do need your consent for, so we can't take them by force. And these are things like blood, urine, semen. So all of those will need you to consent to giving us those samples. Obviously, you don't have to say yes, but it might go in negative against you, really, if you are going to turn around and say no for it. So just be aware that even though we are saying that you can choose whether to give the sample or not, it's better for you if you do give it. Okay, now these samples will be taken if it's going to help the case. So if they think they've found some hair samples or blood samples on a victim and they want to try and match it up and see if it matches you. So it is in your favour generally to give the samples, unless obviously you are guilty, because then they'll match. But you have got the choice whether it's intimate sample, whether to give it or not. But for a non-intimate sample, unfortunately, they can take that by force. Okay, right, that's detention then. So you've got your three areas: detain, interview, searches and samples. You can notice it is a very big question. The detain is 4 bits. Then you've got your interview, that's cats. Then you've got your searches and your samples. You just need to check the question, but more importantly, also check it whether it wants powers of the police or rights of the individual. If it wants powers of the police, you've got to make sure you answer it all as a powers question. If it's rights of the individual, you've got to make sure you answer it as a rights question. So police can only, police must. If it's a mix, do what we always suggest and do a paragraph, include some powers, and then also include a sentence at the end of each, what limits it, or some form of limitation on the police or right of the individual, just so you've covered both bases.